On the one hand, the current approach of setting the cutoff based on the quantum of punishment by a court is imperfect. If one is targeting fitness for office, the current method makes no distinction about the type of offence involved. A fine and/or a short imprisonment term may be imposed by the courts for many offences with varied moral culpability, ranging from traffic offences to theft. Fines may also be imposed for infractions under some laws which many do not consider criminal in nature. Take, for instance, the recent court case involving a member of an opposition party. Shortly before the general election in 2020, he was fined $5,000 for contempt of court. This placed him over the $2,000 disqualification threshold for standing for election. When he applied to the High Court for clarification on his status, the judge ruled that so long as the court fine was of the required amount, it did not matter what the underlying charge was. The court held that matters considered quasi-criminal, such as contempt of court, would suffice for disqualification. On the other hand, imperfect though it is, the advantage of having a cutoff simply based on the punishment quantum is that it is easy to apply and it is clear to everyone. With the raising of the disqualification fine to $10,000 applied to today's circumstances, there will be a better calibration to target offences of greater seriousness. So while today's amendment is a step in the right direction, I understand, and I stand corrected, that in notable jurisdictions such as Australia and the UK, candidates at a natural election are generally not disqualified if they are merely fined in court, whatever the amount. Instead, disqualification kicks in only when one is sentenced to imprisonment of a certain duration. So, given the multitude of regulatory laws in today's modern society, there is always a risk that persons engaged in business or certain industries or professions may be fined for some non-compliance. We may wish to consider in future how relevant the issue of fines is to our disqualification criteria for Parliament. And should we embark on such a further review in the future, careful consideration should be paid to how to balance upholding respect for Parliament as a national institution with having a set of eligibility criteria that is relevant to modern Singapore.